Hello everybody, welcome to Daily News Simplified, an answer to what, why and how of newspaper reading. Today we are going to discuss the Hindu newspaper dated 27th of September of the New Delhi edition. The topics to be discussed today has been presented on the screen. Timestamping for the same has been provided in the description box below. Let us begin our today's discussion. Now the article with respect to the recent judgment of the Supreme Court on the Aadhaar has been covered on page number 1 as well as on the editorial page number 8 of the Hindu newspaper. These articles shall be important from the perspective of GS paper 2 governance under the subsection Indian Constitution. Now on this particular landmark case of Aadhaar, the Supreme Court of India has upheld the constitutional validity of Aadhaar, wherein it has stated that Aadhaar strikes a fine balance between the right to privacy of an individual with the right to life of a same individual as a beneficiary. Now, since Aadhaar strikes a balance between the right to privacy of an individual and the right to life, the Supreme Court has said that the Aadhaar passes the constitutional validity test. However, the Supreme Court has stated that even though the Aadhaar passes the constitutional validity, there shall be certain restrictions on the use of Aadhaar in India. So as part of this video analysis here, firstly we'll be discussing as to what all petitions were filed before the Supreme Court against the use of Aadhaar. Secondly, we'll be discussing as to what was the judgment of the Supreme Court on each of these petitions which were filed. And lastly, we'll not only be understanding as to what was the judgment of the Supreme Court, we'll also be analyzing as to what was the rationale behind the Supreme Court's judgment on the various petitions. So let us now look at the list of petitions filed before the Supreme Court against the use of Aadhaar. Now there were multiple petitions filed before the Supreme Court against the use of Aadhaar. Let us look at these petitions one by one. The first petition was, is the Aadhaar project unconstitutional since it creates a surveillance state? Now with respect to second petition, earlier the Supreme Court of India had declared that right to privacy shall be a fundamental right in India. So the petitioners here argued that the Aadhaar violates right to privacy. The third petition was, should the children be also brought under the ambit of Aadhaar? That is, should the children be also enrolled for the Aadhaar project in order to avail the benefits? Now coming to the fourth petition, as you know, earlier the government had passed the Aadhaar Act as a money bill under Article 110 of the Indian Constitution. So the petitioners here asked whether the Aadhaar Act could be passed as a money bill. And when it comes to the fifth petition, the petitioners here argued that the various sections of the Aadhaar Act such as section 33, 43, 57 are unconstitutional. As to what are these particular sections, we'll be discussing that later in the video analysis. So these are the list of petitions which were filed before the Supreme Court with respect to usage of Aadhaar in India. So having listed out the petitions here, let us now understand as to what was the judgment of the Supreme Court in each of these petitions and on what basis the Supreme Court has arrived at the judgments. Now coming to the first petition, the question before the Supreme Court was whether the Aadhaar project has a tendency to create surveillance state and is thus unconstitutional on this particular ground, wherein the petitioners had raised certain concern with respect to Aadhaar project, wherein the petitioners had argued that the Aadhaar project creates an architecture of cradle to grave surveillance state and the society, which means that under the Aadhaar project, the government would be able to keep a track of an individual from his birth to till death. Thus, by using Aadhaar, the state would be able to track the movement of its citizens, assess their habits, and silently it will be able to influence their behavior throughout their lives. And this ability of the state to monitor the activities of the citizens can be in turn used by the state to stifle dissent and influence political decision making. Thus, the petitioners argued that the authentication of the Aadhaar number enables tracking and tagging of individuals, which means that all the citizens in India will be on an electronic leash. Now let us see as to what was the Supreme Court judgment with respect to this particular petition. The Supreme Court ruled that the architecture of Aadhaar as well as the provisions of the Aadhaar Act do not tend to create a surveillance state. Further, it stated that Aadhaar is giving dignity to the marginalized sections of the Indian society, and hence whatever concerns are raised with respect to the Aadhaar project are lesser than the benefits which would accrue to the people on the implementation of this particular project. Let us now look at the rationale for this particular Supreme Court judgment. The Supreme Court has stated that during the process of enrollment for Aadhaar, minimal biometric data such as iris and fingerprint is collected. Secondly, the Supreme Court has stated that whenever a person is authenticating his Aadhaar records, the requesting agency is provided an answer which includes either yes or no about the authentication of the person concerned. And this requesting agency does not get any information related to the IP address or the GPS location from where the authentication is performed, which means that it is not possible for the government to track movements of each and every citizen in India. Further, the Supreme Court has stated that the government has created a safeguard in the form of Technical and Architecture Review Board and Security Review Committee in order to ensure data protection of all the individuals. Thus, based on these arguments, the Supreme Court has stated that Aadhaar does not create a surveillance state and hence it is constitutional. Now coming to the second petition. The petition here was whether the Aadhaar Act violates the right to privacy and hence it is unconstitutional on this particular ground. Now with respect to Supreme Court judgment here, earlier when Supreme Court had declared that right to privacy shall be a fundamental right in India, the Supreme Court had stated that any restraint on the privacy must be able to pass these three tests. The first one being that it should be backed by a law. Second is there should be a legitimate state aim. And third one is it should be based on the test of proportionality. That means there has to be a balance between the degree of invasion of privacy and the importance of the goal. So with respect to this particular petition, the Supreme Court has stated that the Aadhaar project passes all these three tests which it had laid down in the earlier case. For instance, it has highlighted that the Aadhaar project has been backed by a law wherein the Parliament has passed the Aadhaar Act. Secondly, the Aadhaar project is backed by a legitimate state aim of giving benefits such as subsidies to the people. Further, with respect to proportionality, the Supreme Court stated that the Aadhaar project balances the right of privacy on one hand with the right to food, shelter and employment. So since Aadhaar project passes all the three tests, in this particular petition, the Supreme Court laid down that the Aadhaar Act does not violate the right to privacy of an individual. So finally, the Supreme Court stated that even though the Aadhaar Act does not violate the right to privacy, there should be certain preconditions with respect to implementation of Aadhaar project, wherein the Aadhaar card should be mandatory for receipt of only those subsidies, benefits and services for which the expenditure is drawn from the Consolidated Fund of India, which means that for other benefits and services for which the expenditure is not incurred from the Consolidated Fund of India, the Aadhaar card would not be mandatory. Now coming to the third petition, wherein the petitioners had argued that the children should not be brought within the ambit of the Aadhaar Act. Now with respect to the judgment of the Supreme Court has allowed the enrollment of the children under the Aadhaar Act. However, it has stated that the enrollment of the children should take place only with the prior consent of the parents or the guardian. Further, the Supreme Court has stated that on turning 18, if a child wants to opt out of Aadhaar, he or she will be given an option to exit. Now why this is important is because presently the provision of exiting from Aadhaar is absent in the Aadhaar Act. So this is a new change which has been introduced by the Supreme Court. Further, the Supreme Court has stated that since under the Constitution, education is a fundamental right and hence enrollment under a scheme such as Sarva Shiksha Abhiyan should not require Aadhaar. Now coming to the fourth petition, wherein the petitioners had argued that several sections of the Aadhaar Act are unconstitutional. Now the first section here is section 57, which permits the use of Aadhaar number by the private companies. Now with respect to section 57, the Supreme Court ruled that allowing any corporate or private company to use Aadhaar for authentication would enable commercial exploitation of private data and hence it is unconstitutional. So as you can see here, the Supreme Court has clearly declared that section 57 of the Aadhaar Act is unconstitutional. Now coming to section 33, This particular section provides for disclosure of Aadhaar related information in certain cases, wherein the court can pass an order for the disclosure of Aadhaar related information. With respect to this particular section, the Supreme Court has ruled that an individual whose information is sought to be released must be given an opportunity of hearing and right to challenge any such court order. So this is a kind of safeguard which the Supreme Court has provided with respect to section 33 of the Aadhaar Act. Now coming to section 47. Now section 47 provides that only UID authority can file a court complaint in case of violation of the Act. With respect to section 47, the Supreme Court has ruled that this particular section has to be amended so as to enable filing of such particular complaints by an individual or a victim whose right is violated. What this means is, in case of violation of the Act, the complaint can be filed by both UID authority as well as the individual whose right is being violated. Now coming to the fifth petition, wherein the petitioners had argued that the Aadhaar Act could not be passed as money bill since it does not fall under the ambit of Article 110 of the Indian Constitution. Now with respect to this particular petition, the Supreme Court ruled that the purpose of the Aadhaar Act is to enable the citizens to avail the government subsidies, wherein the expenditure for these subsidies is incurred from the Consolidated Fund of India. So since the Constitution provides that any expenditure from the Consolidated Fund of India should be treated as a money bill, the Supreme Court in this particular judgment has stated that the Aadhaar Act can be passed as a money bill. Further, some important points with respect to Supreme Court judgments are, the Supreme Court has ruled that the Aadhaar PAN linkage can be maintained in future. That is the linkage of PAN card with the Aadhaar is not unconstitutional. However, it stated that there should be no mandatory use of Aadhaar card to open a bank account, as well as there should be no mandatory linking of Aadhaar with the mobile number. So these are the various judgments of the Supreme Court with respect to the Aadhaar Act. Now let us look at some of the previous year prelims question related to Aadhaar. Now both these questions were asked in the prelims 2018. The first question was, consider the following statements. Aadhaar card can be used as a proof of citizenship or domicile. Now this particular statement is wrong because Aadhaar is not a proof of citizenship. The second statement is, once issued, Aadhaar card cannot be deactivated or omitted by the issuing authority. Even this particular statement is wrong because the Aadhaar card can be deactivated or omitted in certain circumstances. So the answer to this particular question is D, that is neither 1 nor 2. Now coming to the second question here. The identity platform Aadhaar provides open application programming interface, that is API. What does this imply? It can be integrated into any electronic device. Now this particular statement is correct. Second statement reads as, online authentication using iris is possible. Even this particular statement is correct. So looking at the options here, the answer to this particular question is C, that is both 1 and 2. Now a mains question for your practice would be, critically examine the Supreme Court's judgment on the constitutionality of Aadhaar card. Does the Aadhaar Act 2016 violate the right to privacy? Give reasons. Now you can try writing answer to this particular question by looking at the video analysis. Now having understood about the various facets of the Supreme Court judgment on the constitutionality of Aadhaar card, let us now move to the next article. This particular article has been taken from the business section of page number 13. The title of the article is Package for Sugar Mills Cleared. This article shall be important from the perspective of GS Paper 3 Indian Economy under the subsection Indian Economy and Various Issues. Let us understand the context of this article. Now the sugarcane industries in India have been facing problems. And these problems has in turn adversely affected the sugarcane farmers in India. So the government has announced this particular package in order to solve the problems which are affecting the sugarcane industries as well as the problems which are affecting the sugarcane farmers. So as part of this video analysis, we will understand as to what are the problems affecting the sugarcane industries in India. Secondly, we'll discuss about the various measures taken by the government in the past in order to address these problems. And finally, we'll be discussing about the recent package which has been announced by the government. Let us now look into the background of this particular issue, wherein we'll be discussing about the problems which have been affecting the sugarcane industry. Now, with respect to sugarcane industry in India, the profits of the sugar industries have been adversely affected due to crash in the sugar prices in India. Now, the graph here shows as to how the sugar prices have declined in India. As you can see in the graph here, in Jan 2017, 1 kg of sugar was costing us 38 rupees. On the other hand, in May 2018, the cost of the sugar has now got reduced to 27 rupees per kg. So this decline in the sugar prices has adversely affected the profit margin of the sugar mills. Now, because of the lower profits, the sugar mills in India have failed to pay money for the sugarcane which they had purchased from the sugarcane farmers, wherein the overall dues of the sugar mills in India has reached almost 23,000 crores in the previous financial year. Thus, this decline in the sugar prices has adversely affected the sugarcane industries as well as the sugarcane farmers in India. So, in order to stabilize the sugar prices and to increase the profits of the sugar mills, the government had taken certain measures in the past. Let us discuss these measures one by one. Now, the first measure which the government had taken in the past was it increased the custom duty on the sugar from 50% to 100%. Now, this increase in the custom duty was mainly done in order to reduce the import of sugar into India. Now, with respect to second measure, earlier the government used to impose custom duty on export of sugar. So, in order to boost export of sugar from India, the government has decided to withdraw the custom duty which it had earlier imposed. Now, coming to the third measure, the government had allocated mill-wise minimum indicative export quota of sugar for export during the sugar season 2017-18. Now, what this means is, under minimum indicative export quota, the government made it compulsory for all the sugarcane industries in India to export certain minimum quantity of sugar. Now, with respect to fourth measure, one of the main problem with respect to sugar industry in India is there has been excess sugar production in India, due to which the prices of the sugar has got reduced. So, because of this, in order to augment ethanol production and further allow divergence of excess sugar for the production of alcohol, the government has given approval for extension of loans worth 4,400 crores through the banks for setting up new distilleries or expansion of the existing distilleries. The main idea behind this fourth measure is to ensure that whatever surplus sugar which the sugarcane industries have should be in turn converted into ethanol. Now, these were some of the measures which the government had taken in the past in order to address the problems of the sugar industries. Now, because of the measures which we have discussed, all India average ex-mill prices of the sugars have increased from rupees 24 to 27 per kg to rupees 30 to 33 rupees per kg. Further, this increase in the sugar prices has led to increase in the profits of the sugarcane industries, because of which the cane price arrears of the farmers have now come down to rupees 13,000 crore from the earlier 23,000 crores. However, in spite of these measures taken by the government in the past, the sugarcane industries are still required to pay almost around 13,000 crore to the sugarcane farmers. So, the new package which has been announced by the government intends to reduce this particular arrears which the sugar industries have to pay to the farmers. Let us understand the package details. Now, in order to help the sugar industries in India to clear the previous cane dues of the farmers, the government has decided to provide financial assistance at the rate of rupees 13.88 per quintal of cane which the sugar industries crush. Which means for every quintal of cane which the sugar industries procure from the farmers, a part of the payment, that is 13.88, shall be borne by the government, whereas the remaining shall be borne by the sugarcane industries. So thus this will reduce the amount of burden on the sugarcane industries. The second aspect of this particular package detail is, in order to ensure the payment of sugarcane dues to the farmers, the government has decided that the assistance would be credited directly into the accounts of the farmers on behalf of the sugar mills. And lastly, the government has also decided to pay for the transportation subsidy which the sugarcane industries may incur for the export of the sugar from India. Now, this transportation subsidy may include the expenditure which may be included for transportation or handling charges at the ports. So, these are the three measures which the government has now undertaken in the new package for the benefit of sugarcane industries as well as the sugarcane farmers in India. Now, having understood the problems of the sugarcane industry and the sugarcane farmers and the measures taken by the government in the past in order to address the problem and the details of the present package, let us now move to the next article. This particular article has been taken from the business section of page number 13. The title of the article is New Telecom Policy Aims to Provide Broadband Access to All Citizens by 2022. This article shall be important from the perspective of GS Paper 3 under the subsection Indian Economy and Various Issues. Now, this particular article has appeared in the newspaper in the context of the release of National Digital Communication Policy 2018, and this particular policy is set to replace the National Telecom Policy which was earlier formulated in the year 2012. So, as part of this video analysis, we will discuss as to what was the need for replacing the National Telecom Policy by the National Digital Communication Policy 2018, the objectives of the new policy, the features of the policy, the strategy which the government has adopted in order to implement the policy, and finally, the components of the new policy. Now, these are the various aspects which we will be discussing in this particular video analysis. Let us now understand the need for replacing the old telecom policy with the National Digital Communication Policy 2018. Now, the modern world has seen a lot of technological advancement which have taken place in the telecommunication sector. Some of these technological advancements are 5G, IoT, that is Internet of Things, etc. So, the government felt that there was a need to introduce a more customer-focused and application-driven policy for the overall development of Indian telecommunication sector. So, it is in this particular aspect the National Digital Communication Policy 2018 has been formulated in place of the erstwhile National Telecom Policy 2012 in order to cater to the modern needs of the digital communication sector of India. So, the main idea behind the introduction of new policy is to take advantage of the new technological advancement in the field of telecommunication sector. Further, according to some of the reports, it is being stated that a 10% increase in the broadband penetration in India could potentially lead to an overall increase in 1% of India's GDP. So, the idea behind the new communication policy is to enhance the broadband connectivity in India, which would not only lead to increase in India's GDP, but would also provide for various kind of benefits of telecommunication services to the people. Now, let us understand the key objectives of this particular policy. The first objective of this policy is to provide for broadband for all. Now, under this particular component, the government intends to provide for broadband connectivity at 50 Mbps to all the citizens in India. Now, with respect to second objective, the government intends to create approximately around 4 million of additional jobs in the digital communication sector. Now, with respect to third objective, presently the digital communication sector in India is approximately contributing around 6% to India's GDP. Now, this particular policy seeks to enhance the contribution of the digital communication sector to almost around 8% of India's GDP. Now, there is an index known as Information and Communication Technology Development Index, which is released by International Telecommunication Union. Presently, India is ranked at 134th position in this particular index. So, as part of this particular policy, the government intends to propel India to within top 50 nations in this particular index. And coming to last objective, the government intends to ensure digital sovereignty of the citizens in India, which means that the government shall take adequate safeguards in order to ensure data privacy of the citizens. And the most important aspect related to these objectives is that the government has stated that all of these objectives are required to be achieved by the end of 2022. Thus, these objectives of the policy would bring about transformative changes in the telecommunication sector by the end of 2022, which would in turn provide for greater benefits to the people. Now, having understood the need for the policy and its objectives, let us now look at the features of this new policy. Now, as we have discussed, this particular policy intends to provide for universal broadband connectivity at 50 Mbps to all the citizens. Now, this is as per its goal of having broadband connectivity for all the citizens in India. The second feature of this policy is it intends to provide for 1 Gbps connectivity for all the Gram Panchayats in India by the end of 2022. Further, it has decided that the speed would be upgraded to 10 Gbps by the end of 2022. Now, this idea of providing connectivity to Gram Panchayat is as per the BharatNet project, which has been conceptualized by the government earlier. Further, with respect to ensuring broadband connectivity for all, it also intends to ensure connectivity to all the uncovered areas. Further, as we have discussed, a 10% increase in the broadband penetration in India leads to increase in the 1% of India's GDP. And accordingly, this particular policy seeks to attract investment of almost $100 billion in the digital communication sector. And lastly, it seeks to establish a comprehensive data protection regime in order to ensure the privacy of the individuals in India is safeguarded. Now, having understood the features of this particular policy, let us now try to understand as to what strategy the government intends to follow in order to fulfill the objectives. In order to provide for broadband connectivity to all the citizens in India, this particular policy advocates for setting up of national digital grid, and this national digital grid will be created by a new agency called as National Fiber Authority. Further, in order to establish a national digital grid, it provides for a collaborative or cooperative institutional mechanism between the center, state as well as the local bodies in India. And lastly, this particular policy aims at removing all forms of barriers for the approvals which would be required for the establishment of national digital grid. Now, coming to the missions, this particular policy has 3 different missions, that is Connect India, Propel India and Secure India. Now, this Connect India mission aims at creating robust digital communication infrastructure in India, which would be in the form of national digital grid, which we had discussed earlier. The Propel India mission aims at enabling the next generation technologies such as 5G, IoT, that is Internet of Things, through investment, innovation and IPR generation. And the last mission, that is Secure India, aims at ensuring the safety and security of the digital communication infrastructure in India. Now, these are the various aspects which you would be required to know with respect to National Digital Communication Policy 2018. Now, a mains question for your practice would be, the National Digital Communication Policy 2018 would take advantage of the new technological advancements and bring about economic development along with enhancing benefits to various sections of Indian society. Discuss. Now, you can try writing answer to this particular question by looking at the video analysis. So finally, to summarize, in this particular video analysis, we have discussed about the need, objectives, feature, strategy and components of the new Digital Communication Policy 2018. Let us now move to the next article. Now, this particular article has been taken from the front page. The title of the article is Center Hikes Import Duty on Select Goods. This article shall be important from the perspective of GS Paper 3, Economy, under the subsection Indian Economy and Various Issues. This particular article appears in the context of imposition of higher customs duty on 19 goods by the government. Looking into the background of this particular decision, earlier the government had announced 5 measures in order to check rupee depreciation. Further, the government had also stated that it will be soon coming out with a list of non-essential items in order to curb the imports. Now, a list of items on which the custom duty has been increased by the government has been shown for your reference. For example, for the air conditioners, the custom duty has increased from 10% to 20%. For the household refrigerator, it has increased from 10 to 20%. Now, with respect to list of items on which the custom duty has been increased is not important from the exam perspective. However, you will be required to understand as to what is the rationale for increase in the custom duty. as well as how this increase in the custom duty would benefit the government. Now let us understand the rationale for the government decision to increase the customs duty. Now the trade deficit in India, which is denoted as total value of export minus imports, has increased due to increase in the international crude oil prices. Now this is evident in the graph shown below, wherein the imports into India have increased. On the other hand, when it comes to exports, the exports have reduced. So looking at the trade deficit, since the exports have reduced and imports have increased, the trade deficit in India has further increased as shown in the second graph here. Now this higher trade deficit has led to higher dollar outflows from India, due to which the rupee has further depreciated vis-a-vis dollars. So the idea behind the imposition of higher custom duty by the government is to reduce dollar outflow from India, which would help in stabilization of the Indian currency. Further, in the article it has been mentioned that the government has sought to impose higher custom duty on the white goods. Let us try to find out as to what exactly are the white goods. Now in case of India, the consumer durables are categorized into two types, that is consumer electronic goods and consumer appliances. These consumer appliances are further categorized into white goods and the brown goods. Now these white goods are considered to be heavy consumer durable goods, which were so far traditionally available only in the white color, but these days one would also come across these consumer durables in different colors. These consumer goods are refrigerators, washing machines, air conditioners, etc. As compared to the white goods, the brown goods are considered to be much lighter goods. And as you can see here, some of the brown goods are mixers, grinders, microwave ovens, etc. Now the government has sought to increase the custom duty on certain white goods such as refrigerator, washing machine and air conditioner. And that is why the concept of white goods has appeared in the article. Let us now look at one of the prelims related question from this particular topic. Now this was a question asked in the prelims 2016. The question was, what are the purposes of government's sovereign gold bond scheme and gold monetization scheme? Now here you have to understand that both these schemes were launched in order to reduce imports into India, as well as to ensure that the gold which is lying in Indian household has to be brought into circulation. So looking into options here, statement number 1 and 3 seems to be correct. On the other hand, statement number 2 is wrong. The answer to this particular question shall be C, that is 1 and 3 only. Now having understood about this particular article, let us now move to the next article. Now this particular article has been taken from page number 7. The title of the article is Boost to SC/ST Quota in Promotions. This article shall be important from the perspective of GS Paper 2 under the subsection Indian Constitution as well as welfare schemes for the vulnerable sections. Now this particular article has appeared in the newspaper in the context of the recent judgment of the Supreme Court on the reservation in promotion for the scheduled caste and scheduled tribes. So it is in this particular aspect, let us try to understand as to what was the judgment of the Supreme Court on the reservation in the promotion for SCs and STs. Now in an earlier case known as M. Nagaraj case, the Supreme Court, which was deliberating on the reservation in the promotion for SCs and STs, had stated that the state should show quantifiable data, and this quantifiable data should be able to prove the backwardness of the members of scheduled caste and scheduled tribe. Upon showing this quantifiable data, the state would be able to provide for quota in the promotion for public employment. However, the Supreme Court in the present judgment has modified this earlier Nagaraj case judgment. So in this particular aspect, let us now understand the background of the previous judgments with respect to reservation in promotion for SCs and STs, and as to how the previous judgments have got modified in the recent judgment of the Supreme Court. Now in the Indira Sahni case, which is also famously known as the Mandal case, which provided for the reservation for the OBCs, in this particular case the Supreme Court had held that the concept of creamy layer is confined only to the OBCs, and the concept of creamy layer would not be applicable to scheduled caste and scheduled tribes. Further, it stated that there should be no reservation in promotion, and the reservation should be confined only to the initial appointments. So as you can see here, the Supreme Court clearly barred for any form of reservation with respect to promotion for the scheduled caste and scheduled tribes in this very famous case. Now, in order to bar the reservation in promotion, the Supreme Court had come up with the argument that the reservation exists only to create a level playing field, that is to remedy the unequal starting position, and hence there is no need for reservation with respect to promotion. Thus, as discussed, the Supreme Court provided for reservation only for initial appointment for both OBCs as well as scheduled caste and scheduled tribes, and barred for reservation with respect to promotions. So in response to the Indira Sahni case, the Parliament passed the Constitution 77th Amendment Act because the government felt that the representation of scheduled castes and scheduled tribes in the services had not reached the required level. So in order to provide reservation in promotion, the legislature passed the Constitution 77th Amendment Act of 1995, wherein this Constitutional Amendment Act added Article 16 Clause 4A to the Indian Constitution. Now this particular article provided that the state can make provision for reservation in the matters of promotion if the state is of the opinion that the scheduled caste and scheduled tribes are not adequately represented in the services of the state. Thus, as discussed, the Constitution 77th Amendment Act added Article 16 Clause 4A, wherein it provided for reservation in promotion for the scheduled caste and scheduled tribe, provided they are not adequately represented in the state services. Now coming to the M. Nagaraj case. Now in this particular case, the constitutional validity of 77th Amendment to the Indian Constitution was challenged. Now in this particular case, the Supreme Court upheld the constitutional validity of the 77th Amendment Act and stated that these are mere enabling provisions. Now this means that the state government can make provisions for reservation to SCs and STs with respect to promotion. However, the Supreme Court laid on three conditions. The first condition being the state has to collect quantifiable data, and this quantifiable data should show the backwardness of the class. Secondly, it stated that the reservation can be provided only when there is inadequacy of representation of the class. And thirdly, it stated that the reservation can be provided only when the efficiency of the administration can be maintained. Thus, in the Nagaraj case, the Supreme Court allowed for promotion for the members of SCs and STs. However, it laid on three different restrictions. The first restriction is with respect to backwardness of a class, for which the state would be required to provide for quantifiable data to prove the backwardness. The second one being inadequacy of representation, and the third one being the administrative efficiency. Now this particular administrative efficiency has been covered in the Article 335 of the Indian Constitution, which states that the claims of the members of scheduled caste and scheduled tribe shall be taken into consideration by keeping in mind the maintenance of efficiency of the administration. What this means is the reservation in the promotion should not adversely affect the efficiency of the administration in India. Now let us understand as to what was the judgment of the Supreme Court in the present case. Now this case is also referred to as Jarnail Singh versus Lakshmi Narayan Gupta. In this particular case, the Supreme Court stated that there is no need to revisit the judgment of M. Nagaraj case by a 7-judge constitutional bench. Now one important change which Supreme Court has introduced here is earlier, as we discussed in the Nagaraj case, the Supreme Court had stated that the government had to provide for quantifiable data in order to prove for the backwardness of scheduled castes and scheduled tribes. However, in the present judgment, the Supreme Court has stated that the states would no longer be needed to collect the quantifiable data in granting the quota in the promotions. However, in granting quota for the promotions, the Supreme Court has stated that the states will have to back up the promotion with the data to show that there is inadequate representation of the SCs and STs in the cadre. Further, the most important change which the Supreme Court judgment has introduced is it has stated that the principle of creamy layer can be extended to members of SCs and STs in order to give promotions in the government jobs. So with respect to Nagraj case, there are two important changes which the Supreme Court has introduced. The first change being the states are no longer required to provide for quantifiable data in providing for the reservation for SCs and STs. And secondly, the Supreme Court has stated that the principle of creamy layer can be extended to the members of SCs and STs with respect to promotions in the government jobs. Now these are the two important changes introduced by the Supreme Court as compared to the previous Nagraj case. Now these are the important aspects which will be required to know with respect to the recent judgment of the Supreme Court with respect to reservation in promotion for SCs and STs. With this, we have come to end of today's discussion. Now let us look at the question for the day.